I believe we have a question from Mr. Ramesh Babu. We can ask him to speak. Maybe we can just take this one question because we're anyways running out of time.
Yes. Mr. Ramesh Babu can speak about his questions.
Hello.
Yes, please.
Hello, am I audible?
Yes, you are.
Yeah, regarding one small point, regarding the security receipts, every 6 months the security receipts are to be rated by credit agencies, credit rating agencies.
Yeah.
In case there is a fall in the rating, and to that extent, the provision is to be made either by the ARC or the bankers which are holding the security receipts. This small information just I want to add.
No, see, the security receipts are assets in the books of banks,
Yes,
and
sir.
the security receipts are not a kind of liabilities in the books of ARCs. So therefore, the provisions will have to be created in the books of banks. Namaste. Good morning. Welcome to 163rd episode of AAA Weekly Webinar Series. We started with a complete learning program on asset reconstruction companies. Part 1 was delivered last week, episode number 162, and today we are delivering part 2. The topic is a little longer, so it may even take more than 3 episodes for providing a complete understanding of asset reconstruction companies, including the RBI guidelines, directions, and various judicial pronouncements. We are still going on about explaining the law relating to asset reconstruction companies. Then we will come to the RBI directions, and then we will come to the judicial pronouncements. Today, in part 2 of this a learning series on asset reconstruction companies, we would be continuing with the part of SARFAESI law, the SARFAESI Act, which is relevant to asset reconstruction companies. We are not touching the enforcement of security interest part, and we are also not touching the institution or establishment of central registry. However, the relevant part which is applicable to ARCs, that is being deliberated today as well as in future it will be done. So this is what we are presently, what we are saying, that this legal framework and evolution of ARCs, that's what we are doing today. So in the part 1, we have in fact deliberated on why ARCs were required in India, and then similar laws and efforts made by other jurisdictions, other countries. We also discussed about Tiwari Committee. We also discussed about the SARFAESI law promulgated in 2002, when this concept of ARCs in fact were initiated in India. Then we discussed registration of ARCs, cancellation of certificate, and we also deal with the acquisition of assets, which is the most important part of ARCs existence. Acquisition of assets were all discussed, and also once the acquisitions are, once the assets are acquired, the ARCs can step in and act as claimant or litigant in place of the assigner bank. The notice to the obliger means the borrower, the notice to the obliger and discharge of obligation, that's what we actually can talk about. And then we actually, we see that we now today, we would be discussing on issue of security receipts by ARCs. How the SARFAESI law has enabled ARCs to issue security receipts to qualified institutional buyers. Qualified institutional buyers, these security receipts can be issued to qualified institutional buyers. These security receipts, in fact, represents a right to receive recoveries from the underlying financial asset. Right to receive recoveries from the underlying financial assets. These are regulated and monitored by RBI. Now, see, SARFAESI does not define qualified institutional buyers. However, RBI guidelines align with the definition provided by Securities and Exchange Board of India, SEBI. The qualified institutional buyers include mutual funds, venture capital fund, alternative investment funds, foreign portfolio investors, public financial institutions, scheduled commercial banks, insurance companies, pension fund, and provident fund. So these entities are considered to have expertise and financial capacity to invest in complex financial instruments like security interest. Now, how the Section 7 of the SARFAESI Act deals with issue of security by raising of receipt or funds by asset reconstruction company. So Section 7, subsection 1 says, first of all, it is a non-obstante clause. So when this is being done under SARFAESI law, first of all, the provisions of Companies Act, the provisions of SEBI, or the Securities Contract Act would not be applicable on issue of such SRs, such security receipts. These issues would, these provisions of Companies Act, SEBI, and Securities Contract Act would not be applicable because these security receipts are being issued or these debentures are being issued under SARFAESI law. And because of this non-obstante clause, the three acts, the provisions, relevant provisions of three acts like the Companies Act, SEBI, and Securities Contract Regulation Act would not be applicable. So therefore, the ARC may, after acquisition of the financial asset under subsection 5 that we explained in the last episode, offer security receipts to qualified institutional buyers or such other category of investors, including non-institutional investors, as may be specified by the Reserve Bank of India in consultation with the board from time to time for subscription in accordance with the provisions of those acts. However, we have seen that in this particular case, when we say in consultation with the board, this means SEBI. Because see, the board is defined in this act as SEBI. And also the non-institutional investors, as may be specified by the Reserve Bank of India. So till now, there has not been any such non-institutional investor which has been specified by Reserve Bank of India. So therefore, presently, issue of SR is restricted to only qualified institutional buyers, which we have already said: mutual funds, venture capital fund, alternative investment fund, foreign portfolio investment, public financial institutions, scheduled commercial bank, insurance companies, pension fund, or provident. So these security receipts would be issued, and it will be issued only to the qualified institutional buyer, because non-institutional buyer, there has not been any notification issued by RBI so far. However, RBI issued a draft guidelines because of the third framework, RBI-led framework for resolution of NPS or assignment of NPS. So once those guidelines, which was draft till last month, once those guidelines will be notified by RBI, that would actually start some era where the non-institutional investor would also be possible for them to invest in NPS or take assignment as bouquet of assignments. That is where we may wait for some time. So Ankit, we have started because since there was a little delay, so we've started with the part 2 of ARC law, also we will come for RBI guidelines and also judicial pronouncements, as the subject is taking longer, so it may be more than 3 episodes. Anything that you would like to add, and then we will actually talk about. We are presently talking about issue of securities by raising receipts. That means by raising security receipts or funds by ARCs. Yes, Ankit.
That's perfectly okay. I think we can carry on, and I think after some time we can take some questions when they come along.
So section 7, subsection 2 of SARFAESI deals with ARC may raise funds from the qualified buyers for formulating schemes for acquiring financial assets. So the ARCs can form a scheme. In that scheme, ARC can take funds from qualified buyers, qualified institutional buyers, and for acquiring financial assets. Now that scheme may be that there may be a scheme which is prepared for a particular qualified buyer who is interested only in one segment of NPAs. One may be interested in retail, one may be interested in specified, maybe power industry, one may be interested in chemical industry. So there are schemes which will be drafted by ARCs for acquiring financial assets and to raise funds from the qualified buyer. So there may be some qualified investors, there may be some QIBs. They may be interested that I am interested only in the retail portfolio of home loans. So that where the schemes can be formulated by ARCs to raise funds from qualified institutional investors. Then in that case, in case such scheme is formulated by ARCs, then ARC is under obligation to keep and maintain separate and distinct account in respect of each such scheme for every financial asset acquired out of investments made by a qualified buyer. So ARC is under obligation to maintain separate and distinct account in respect of each such scheme, and to ensure that the realizations of such financial assets is held and applied towards redemption of investments and payment of return assured on such investments under that relevant scheme, so that relevant scheme can also assure some kind of return to qualified investors. And that scheme can also have some kind of repayment schedule. That scheme can also have some kind of returns. So any realization from those assets will have to be separately, completely distinct accounting, completely distinct management, and then that will be only and only used for redemption of investment and also for making payment of their return on investment. Going forward, as far as the security receipts are concerned, whenever there is a scheme, so the scheme for the purpose of offering security receipts under subsection 1 or for raising funds under subsection 2 may be in the nature of a trust to be managed by the asset reconstruction companies. So now there are trusts which are being made. Now those trusts will also use the funds given by the institutions. And those trusts, there will be conditions of management of those trusts. And that trust, then the trustees can also be, those investors can also be trustees. Those investors can also do the management of all these NPAs which are acquired out of their funds under its scheme. And then the ARC shall hold the assets so acquired or funds so raised for acquiring the assets in trust. ARC will hold in trust for the benefit of qualified buyer holding the security receipts or from whom the funds are raised. So there can be a cluster of investors who are holding security receipts of a particular scheme. There can be an institutional investor who are investing in that scheme, and that scheme can be in the form of a trust. The trustees can be a combination of the ARC representatives and also the investor representative. So this is where the most of the trusts are being created. Most of the security receipts are being issued to QIBs, and when the trust is made, the provisions of Indian Trust Act shall be applied, except those provisions which are inconsistent with the provisions of SARFAESI, specifically to ARCs, then the SARFAESI would be applicable. So the trust would be regulated as per the Indian Trust Act. However, in case there is any inconsistency in the Trust Act as well as in the SARFAESI Act, then in that case, SARFAESI law will provide as far as that law relating to ARC is concerned. This is where we are trying to say that how the security receipts are being created, how the trusts are being created, and how the investors are investing in secured NPS or investing in NPS. Now the RBI is coming with a scheme that even other than ARC route, the investors, the qualified investors, the non-institutional investors, they will also be able to invest in NPS. That is what is the new scheme of RBI which is coming, which the draft has already been released and it might be notified any day. Now going forward, in the event of non-realization under subsection 2 of the financial asset, in case the financial assets are not realized, in case the ARC is not able to realize from those financial assets which are acquired for the purpose under a scheme or for the purpose of a trust, the qualified buyer of the ARC holding security receipts, those people, those investors who are holding security receipts of not less than 75%. So the powers here given to the investors is that they have to collectively reach out to the ARC with 75% of the voting and then shall be entitled to call a meeting of all the qualified buyer, and every resolution passed in such meeting shall be binding on the company, means ARC. In case ARC is not able to realize from the financial assets acquired under that scheme or under that trust, then all those investors who are holding 75% share in that investment, maybe in the shape of SRs or in the shape of trust, they can call a meeting and they can take any decision. And whatever decision would be taken, that will be binding on the company, that means ARC. So they can also take a decision to withdraw the investment or to change to another ARC. So they can take any kind of decision. So the qualified institutional buyer or the qualified buyer at a meeting called under this section, in this section, will follow the same procedure as normally we follow for conducting a board of directors meeting. And when we talk about procedures, that means issue of notice, how to conduct the meeting, recording of minutes, taking attendance, everything would be applicable as if it is a board of directors meeting. So that relevant part of the Companies Act would be applicable for conducting these meetings. So this is what is the security receipts. This is what is the concept of trust. And this is where we are saying that finally the investors, if they collate, if 75% of them are together, they can take any decision and that would be binding on the ARC. Yes, Ankit, any comments from your side?
No, that's okay. I think we can continue, yes.
Okay. So now moving forward to section 8, exemption from registration of security receipt. This is a benefit which was extended under the SARFAESI law to the acquisitions, to assignments. So whenever, this is again a non-obstante clause. This actually is a non-obstante clause over and above the Registration Act of India. It means that any security receipts issued by the ARC by the ARCs under subsection 7 and not creating, declaring, assigning, limiting, or extinguishing any right, title, or interest to or in immovable property, except insofar as it entitles the holder of the security receipt to an undivided interest afforded by a registered instrument. Any transfer of security receipt shall not require compulsory registration. So the exemption from registration, exemption from stamp duty is only having one, it is only having one exception, that the security receipt is whatever security receipt is being created. There is only one exception in case that security receipt is not creating, declaring, assigning, is like or any interest or in see except insofar as it is entitled the holder of the security receipt to an undivided interest. So it has to be undivided interest given to all the assets. It has to be undivided interest given to all the institutional investors. Then only the registration is not required. Otherwise, there can be a possibility of misuse of this section. So therefore, in case it is a collective assets, in case it is a proportionate share in the total secured asset, then registration is not required. But in case we create security receipts and we give it to one non-institutional investor, and this can be used as kind of as a kind of tool to save stamp duty. So therefore, this exemption has only one limitation, that it has to be undivided interest to given to a registered instrument, undivided interest afforded by the registered instrument. Now, Section 9 is very important. What are the powers of asset reconstruction company for resolving the NPA? This is also called in common toolkit. This is also called toolkit. Now, the toolkit, in fact, refers to the menu of strategies legally permitted for ARCs to recover, restructure, or resolve bad loans. So this is a toolkit. The ARCs has a toolkit, and they can use any tool to resolve, restructure, or and even recover the bad loans. These are typically mentioned in Section 9 of the SARFAESI Act and also in RBI guidelines. We will come to RBI guidelines in our next episode, but today we are only trying to say that what is the toolkit available to the ARCs? What are the total tools available? So let us try to understand that again. This is again a non-obstantive clause. Non-obstantive clause means that this is overriding to all other laws. It is written in the Section 9 of SARFAESI Act that without prejudice to the provisions contained in any other law for the time being in force, an ARC may, for the purpose of asset reconstruction, provide for any one or more of the following measures. That measures 1 to A to G are the various tools available with the ARC to recover, resolve, or restructure NPA. 1. The proper management of the business of the borrower by change in or takeover of the management of the business of the borrower. The ARCs can take over the business of a company. The ARC can even change the management of the company, and the ARC can also sell or lease of a part or whole of the business of the borrower. ARC can reschedule payment of debt payable by the borrower and also can do enforcement of security interest in accordance with the provisions of section like 13.1 to 13.4 of the SARFAESI law, where the ARC can also take physical possession, and ARC also can directly sell those assets in the market, and the money will come to them without going to any court. ARC can also settle the dues. So the ARC can also enter into a one-time settlement of the dues. They can also take the possession of the secured assets in accordance with the provisions, and also conversion of any portion of debt. Conversion of any portion of debt into the shares of the borrower company. Into shares of the borrower company. However, for conversion of any part of the debt into shares of the borrower company shall be deemed always to have been valid, as if the provisions of this clause were in force at all material times. So those conversion will be valid. That conversion of any part of the debt into shares of a borrower company shall be deemed always to have been valid. So that is something which no questions can be asked in case a particular loan is converted into debt or a part of the loan is converted into debt. So moving forward, we can say the Reserve Bank of India has been empowered for the purpose of this section 1, determine the policy and issue necessary directions, including the directions for regulation of management of the business of the borrower and fee to be charged. This is also very important that the RBI has given such directions, and we will discuss RBI directions regarding how the management of the business of the borrower and the fee to be charged. Then the ARC shall take measures under these sections in accordance with the policies and directions of the RBI. So we can now see that there are various places where in SARFAESI law, the Act has mentioned that the RBI will come out with the policy, RBI will come out with the directions. So we will read about the RBI policy, RBI directions in our subsequent episodes. Now, we have discussed the acquisition of assets by ARCs. We have discussed how the security receipts can be issued, or even in some cases, debentures can also be issued without taking any approval from SEBI or Securities Contract Regulation Act or even the Companies Act. Then we have also seen how the ARCs, what is the ARC's toolkit? The toolkit of the ARCs include various measures that can be taken by ARCs to recover, resolve, or restructure an NPA account. That's what we have seen. The major part of the ARC's role, like taking assignment of NPAs and then recovering, restructuring, or resolving the NPAs, that we have already seen. Now let us see what else the ARCs can do. What else ARC can do? So this particular section 10, in fact, gives some powers or some entitlements to ARCs that they can do some other things also. Now, any asset reconstruction company registered under section 3 may. The ARC can also act as an agent for any bank. Agent for any bank or financial institution for the purpose of recovering their dues from the borrower on payment of such fee or charges as may be mutually agreed upon between the parties. So the ARCs can take a bouquet of loans from banks, and they can even make efforts for recovery, which will be fee-based. So they would be, in fact, charging a fee, and based on that fee, they would be recovering. They will have the powers to recover. They can also act as manager. They can also act as manager as referred in section 13, subsection 4, on such fee as may be mutually agreed upon between the parties. So the ARC can also be appointed as manager. ARC can also appointed as bank's agent for recovery. They can also be appointed as manager in case the banks take over the management and control of the borrower's assets. Then also act as a receiver if appointed by any court or tribunal. So the ARC can also act as a receiver if appointed by any court or tribunal. This is where, provided that no ARC shall act as manager if acting as such gives rise to any pecuniary liability. So when you are acting as a manager, there is no possibility that you can give any indemnity, you can give any guarantee, so that the ARC's own net worth comes under some difficulty, because that will be only and only fee-based, and ARC will not enter into any contract to act as manager in case that particular agreement or that particular contract gives rise to a pecuniary liability. So that means it will be only and only fee-based. It will not be having any assurance from the ARC regarding the amount of recovery. It will not have any indemnity clause. The ARC will not be able to do any indemnity. So this is what is the ARC's other business that the ARC can do. Also, the ARC, which has been granted a certificate of registration, shall commence or carry on, basically the no ARC can commence. No ARC can commence the business or carry on the business without prior approval of Reserve Bank of India. So any business other than that of securitization or asset reconstruction companies. So this means that no ARC can carry on or continue with any business other than securitization or asset reconstruction. Again, there is a proviso which says that the ARC, which is carrying on, in any case, there were some companies which started the ARC business while they were having some other businesses already in hand. So in case of such cases, they will cease to carry on any other such businesses within 1 year of the date of commencement of the ARC business. So for the purpose of this asset reconstruction company, the subsidiaries of the ARCs are not included. For that means that when this ARC was formed, at that time, the ARC in fact has stopped doing any other business other than securitization and asset reconstruction. However, if there were any subsidiary company of the ARC, so those will continue, and this particular section where the ARC will have to exit from all other businesses, that will not be applicable to subsidiary companies. This is what is the other functions of the ARC. So what we have seen, ARC can act as agent for recovery on behalf of the lenders. ARC can act as manager in case the lenders have taken over management. ARC can act as a receiver also. And these ARCs can only do this business. ARCs are not allowed to do any other business other than securitization or asset reconstruction. That is what the ARC's main job is. Then, coming to the resolution of disputes, where there is any dispute which arises regarding securitization or reconstruction or non-payment of any amount due, including interest, arises amongst any of the parties, namely banks, financial institutions, or ARC or qualified buyer, such disputes shall be settled by conciliation or arbitration as provided in Arbitration and Conciliation Act, as if the parties to the dispute have consented. So even if the agreement of acquisition, even if the agreement between the trustees, even if the agreement between the financial institutions or investors do not mention anything about the dispute resolution, then Section 11 would be applicable, and it will only go to arbitration and will not go to any other court for resolving. Now we also move to Section 12, which says that the powers of Reserve Bank of India to determine policy and issue directions, and the RBI, in case the RBI is satisfied in public interest to regulate financial system of the country to its advantage, to prevent the affairs of any ARC from being conducted in a manner detrimental to the interest of investors, or in any manner prejudicial to the interest of such ARC, it is necessary or expedient to do. So whenever the RBI feels it is necessary or expedient, it is in public interest, it is for regulation of financial system of the country, and it is for the benefit of the ARC, the RBI may determine the policy and give directions to all or any ARCs in the matter. So the RBI can give such kind of such kind of policies or directions regarding income recognition, how the income will be recognized by ARCs, what would be the applicable law for income recognition and asset classification, what kind of accounting standards should be used by the ARCs for making their financial statements and for the disclosures, what kind of provisions would be, under what provisions the RBI, the ARCs will provide for bad and doubtful debts, what would be the capital adequacy ratio based on the risk weights of the assets. Also relating to the deployment of funds by ARC, as the case may be, the such company shall be bound to follow the policy so determined and directions so issued. RBI has taken the complete powers to release policy and even the directions for all these issues, which is there on the screen: income recognition, accounting standards, bad and doubtful. All this, the RBI has the power, and also the RBI will have other powers. Generally, vested powers with the RBI may give directions to any ARC. RBI has the power to give directions to any ARC, generally to or to a class of ARCs or to any ARC in particular as such. And that directions, that directions can be on account of the type of financial assets of a bank or financial institution which can be acquired and the procedure for acquisition of such assets and valuation thereof. Aggregate value of the financial assets which may be acquired by any ARC, that can also be fixed by the ARC, by the RBI in some cases. The fee and other charges which may be charged or incurred for management of financial assets acquired by any asset reconstruction companies and the transfer of security receipts issued to qualified buyer. So for all this, the RBI is making policies, RBI has made policies, RBI is giving direction, has given directions, and we will come to the various RBI directions. We will come to the various policies that the RBI has released. So now we can move to section 12A, that is power of RBI to call for statements and information. Ankit, now I think it has become procedural. I would like you to add so far, or we can take questions if there are any questions.
So in case I look at the questions, I see that so whether ARCs can acquire already converted debt into equity by banks. So that's a question. That is a practical question.
No, I don't think the equity, already converted equity cannot be acquired. Because see, in case the debt has already been converted into equity fully, then that means unless there is a clause which empowers the bank to go back to the original loan agreements, and all this can be all these equity shares conversion can be reversed, which is not possible under the Companies Act or under any other act. Once a debt is converted into equity shares of the company and the bank has accepted them as equity share investment, after that it is no more a secured debt. It is no more there is no secured asset, and it is not possible to have NPA. So this is not unless there is a kind of clause that everything will be reversed in case of failure of the terms and conditions of share subscription agreement, which might have been entered between the company and the financial institution. Yes, Ankit.
Right. Then, of course, we have a question that historically, which mode has been beneficial for ARCs for resolution or recovery, SARFAESI or IBC? I believe it can be both. It will depend on the nature of the asset. Also, I see that ARCs also do a lot of settlements because they would, put all guns out and make sure that the borrower then kind of also they can also settle in case they feel that yes, it is taking time and the borrower is ready to pay upfront. That's also possible.
Yes, Ankit, I think when the ARCs go to route of IBC or they go to route of SARFAESI, so there are many factors that the ARCs would consider. One, that for SARFAESI, they should have an identified asset, and that identified asset should have an separate segregable value. And then that identified asset should be sellable separately. So these are the conditions of basically invoking SARFAESI law as against IBC. And when the ARCs feel that everything is working and it's running and it is a better value realization in case it is sold as a going concern, then the ARCs would definitely go for the insolvency law.
Right. Then what happens in case an ARC takes an assignment and it just doesn't do anything about it. It just keeps it with it, and they have issued some security receipts, but they don't take action on this. And I think this is also with reference to some of the ARCs and their practice where they used to take over assignment of a loan, and then they used to kind of get some kind of a remuneration from the management or the borrower, while the borrower used to keep working the company. So
I think we've already discussed that in case the ARC is not able to recover, then all those investors who have been given SRs, security receipts, 75% of them, in case they all agree, then they will pass a resolution. And when they pass those resolutions, it will be binding on the company. It will be binding on the ARC. So in case there is only one, original lender, and then ARC, so then they are certainly 75%, and they can take a decision of changing the ARC, or they can take a decision of uh, going back and reversing the assignment. So that is also possible under the SARFAESI law.
right. Then we have a query that how does the ARC decide on pricing for acquisition of NPAs from financial institutions or banks, and is there any specific market practice? So I can answer this, I believe, because we in AAA valuation we do a lot of valuations for ARCs for the buy side, where ARCs give us a portfolio of assets that has come out from the banks for them to kind of participate in the auction. So they kind of participate in a auction kind of a process for that bouquet of assets, and they would get some information about those assets based on which they will get a valuation done on the collateral security involved. They then ask us as valuers to visit those properties, see them from outside, inquire in case there is any litigation or any difficulty with respect to that asset that the neighborhood knows about. And so they do a limited kind of due diligence in that manner also. And then based on the valuation that we give, we understand that they would do some kind of a discounting or some kind of a margin they will keep, and then they will decide to quote accordingly. So this is the practice that we have seen when they acquire assets.
Yes, I think then there is a process of
We have
conducting an
also been
auction.
part of a due diligence come valuation process for NARCL, and that is even more thorough, where they kind of do a very thorough analysis of what the debt is, what is the kind of value of assets or the value of the company which is a going concern, what will be the kind of what is the possibilities of making that asset usable or good. So all that is something that they do.
Yes, I think after all this due diligence, there will be some value, and there are two possibilities. One is the Swiss challenge method, and the other is bidding method, where different ARCs will come for bidding, or they can even or the lender, the original lender, can even use the uh, Swiss challenge method also.
Right. Then whether the security receipts are part of net owned fund, or is it treated as deposit or debt? This is the question. I think this is from the point of view of the balance sheet.
See, these security receipts, in fact, is a liability for the ARCs.
Yeah, I think this
Security
is the bank
receipts
side
are just
question.
like debentures for ARC. So this is not considered as net owned funds.
Question is from the bank side.
From the bank side. From the
Yeah,
bank side, the security receipts would be considered as as an asset. It will be considered as an investment, and it will not be considered as NPA.
yeah, and it will be as an if it is considered as an asset, then again it will be subject to the prudential norms. So in case the security receipts, if the underlying NPA loans which are there under the security receipts, if they are NPAs, then the prudential norms will apply or not apply. I think that's the question that we need to answer here.
On all kind of assets, the prudential norms would be applicable. I mean, the whatever SRs or debentures are issued, and then the prudential norms would be applicable. Income recognition and asset classification norms would be applicable.
So in case the bank issues an SR, which kind of allows the bank to get an upfront payment, that upfront payment, of course, is realization. So that will be added as an income to the P&L in case the bank has already provisioned 100% for that NPA. Similarly, in case the SR allows the bank to get some money at a later stage from the realization of future value from the assets or future sales from the assets, that also will go into the P&L of the bank, and the SR in itself will of course be valued only in case the RBI prudential norms allows for some valuation for the underlying asset.
I think Mr. Ranjan has also raised hand in case we can take him for some questions.
You will have to do that or make me a co-host.
Okay. So I can see the attendees are there, and I can ask Ranjans to unmute and speak, please.
Sir, am I audible, sir?
Yes, you are.
Sir, actually, what is the capital structure of the ERCs? Whether foreign investors and foreign members can be inducted in this, and what is the minimum net worth criteria for forming an ERC?
So the minimum net worth criteria as on today is 300 crores. Any existing and ARCs, they have to bring their net worth to 300 crores by 31st March 2026. So for any new ARC, the net owned fund are required to be 300 crores.
Whether foreign members can join as an shareholder or in any other form, that is, he is the member of this ARC, or their
It
net
is
worth would be.
subject to any ARC, when it is actually, let's see, like when we discussed in our first episode, what are the requirements for registration of an ARC. So like the promoter of the ARC has to be very clearly, the promoter of the ARC will have to be very clear RBI approval. Now, RBI approval is important for the purpose of the registration. I can actually say, like, not net owned fund 300, as I said, and RBI pre-approval is required. And then, like, there is nothing which is restricting so far the investment from overseas. So there is nothing which restricts as of now.
Yes, sir. Thank you.
So
Continue.
yeah, we should continue, Ankit.
Yeah.
So quickly, we would be finishing the basic law regarding SARFAESI, regarding the ARCs in the SARFAESI Act. So we are now discussing the powers of the Reserve Bank of India to determine policy and issue directions. So Reserve Bank of India has taken powers out of the SARFAESI law, as the Reserve Bank of India can issue a policy or can determine direction. Can determine a policy or issue directions in case the RBI is satisfied that it is in the public interest, or RBI is satisfied that to regulate financial system of the country and its advantage. And then if the RBI feels that whatever we are doing, it is only to prevent the affairs of any ARC from being conducted in a manner detrimental to the interest of the investors, or in any manner prejudicial to the interest of such ARC, and it is necessary or expedient to do so, then the RBI can determine a policy and give directions to all or any ARC, and that directions or that policy that can be related to income recognition and what should be the accounting standard for ARCs, making provisions for bad and doubtful debts, capital adequacy based on risk weights for the assets, and also relating to the deployment of funds by ARCs. So as such, company shall be bound to follow the policy so determined and directions so issued. So RBI's policy and directions would be binding on ARCs. Now, in any, see, this is another power that this RBI has taken without prejudice to generally or of the power vested under subsection 1. RBI may give directions to any ARC generally or to a class of ARCs to so as the type of financial asset of a bank or financial institution which can be acquired and procedure for acquisition of such assets and valuation thereof. 2. The aggregate value of the financial assets which may be acquired by any ARC. 3. At the fee and the other charges which may be charged or incurred for management of financial assets acquired by any asset reconstruction company, and then transfer of security receipts issued to qualified buyer to any other person. That is where the RBI is giving directions and determining policy, which we would be discussing in the subsequent episode. That will be episode 164. Then the RBI has also taken powers under section 12 capital A that at any time the RBI can at any time direct an ARC to furnish within such time as may be specified by the RBI with such statements and information relating to the business and affairs of the such ARC, including any business or affairs which such company is concerned. See, and then the Reserve Bank of India may consider necessary or expedient to obtain this for the purpose of this act. So that kind of information which can be obtained, and the that is from something the RBI has the power to call for the statements and information about the business or affairs of the ARC. Then the RBI has also taken powers under section 12 capital B to carry out audit and inspection. So the Reserve Bank of India, for the purpose of this act, carry out or cause to be carried out audit and inspection of the ARC from time to time. And then in case of such inspection or audit is ordered by RBI, then it would become the duty of the ARC and its officers to provide assistance and cooperation to the Reserve Bank to carry out audit or inspection under this section. And then when an audit or inspection is going on or otherwise, the RBI is satisfied that the business of the ARC is being conducted in a manner detrimental to public interest or to the interests of investors in security receipts issued by such asset reconstruction company. The Reserve Bank of India may, for securing proper management of an management of an ARC by order, and the Reserve Bank of India can in fact pass orders for securing proper management of ARC, and those kind of orders includes the orders which RBI can pass includes the remove the chairman or any director or appoint additional directors on the board of directors of ARC. That is the first thing the RBI can do. Secondly, appoint any other officers of the RBI as an observer to observe the working of the board of directors of the asset such of the ARC. Now, provided that no such order of removal of chairman or director shall be made except after giving him an opportunity of being heard. Once such inspection and auditing is given, it is the duty of every officer or other officer or employee of the ARC to produce before the person conducting an audit and inspection all such books, accounts, and other documents in his custody or control, and provide him such statement and information. That's what is the important part. Then there is a requirement. There are requirements regarding filing of transactions of securitization or reconstruction and creation of security interest. So this requirement is for central registry, which is called in short SARFAESI, CERSAI. So what this section 23 mandates, and it actually puts an obligation to the ARCs that every installments of securitization, asset reconstruction, or creation of security interest shall be filed before the central registry. That means SARFAESI. in the manner they will provide in the rules. They have already provided in the rules. And then provided that the central government may by notification require registration of all transactions of securitization or asset reconstruction or creation of security interests which are subsisting on or before the date of this amendment. So when this amendment, when this section 23 came in SARFAESI law, at that time, any such asset which is available with any bank or any financial institutions and for which no such registration has actually been done. No such registration have actually been done. And the central government has by notification powers to registration of the transactional auditor to different kind of security interest. Central government may also by way of rules provides form for registration of different type of security interest under this section and the fee to be charged to such actions. So any such modification which is required for, since the SARFAESI registration has been done, means central registration has been informed, and if there is any modification, that has to be informed to SARFAESI central registry under section 24, and then under section 25, the ARCs or secured creditors, they are supposed to report satisfaction of security interest in case they have realized their security, they have sold the asset, or they have transferred the management to any other third party. They are under obligation. They are under obligation to submit the satisfaction of security interest. That's very important. So this is what is the report required. Now we only have to say that the right to inspect. Now under section 26, RBI has also kept a right to inspect the securitization, reconstruction, and security interest transactions. The particulars of securitization or reconstruction or security interest and enters in the central registry. So it can be inspected, central registry, and the central registry, in fact, maintain an electronic form shall also be opened during the business hours for the inspection of any persons through electric. So in case there are a lot of registrations have already been done before SARFAESI, and in case of any such kind of inspection can be ordered, or they can even inspect the transactions, RBI can actually do all this to control this segment. Then a rectification by central government in the matters of registration modification. So whenever there is a registration or modification of the ARC's charges, which they have taken from the original lenders, that also is been attended by section 26A, and that says the central government on being satisfied that the omission to file the registrar the particulars of any transaction of securitization, asset reconstruction, or security interest, or modification or satisfaction of such transactions, the omission or misstatement of any particular with respect to any such transaction or modification with respect to any satisfaction or other entry made in pursuance of section 23 or section 24 or section 25 of the Principal Act was accidentally or due to inadvertence to some other sufficient clause, or it is not in nature to prejudice. So that's what is then the central rectification also would have central government rules and powers. Now, even the offenses are also mentioned. Section 27 also talks about that penalties can be levied on ARCs in filing under section 23 the particulars of every transaction of any securitization or asset reconstruction or security interest created by an ARC or secured. It actually if there is a default, and if there is a default in sending under section 24 the particulars of modification, and also in giving information under section 25, every company and every officer of the company or the secured creditor, every who is in default shall be punishable with fine which may be extended to 5 or it will be fine which is to 5,000 rupees for every day within which such default continues. So there are offenses, there are penalties. And of course, the penalties can be levied only with a representation from others. Cognizance of offense also, we can see that the cognizance of offense is also important. So this is what, Ankit, we can take some of the questions. So we have done our part regarding the various ARC formation and ARC management. And in the next episode, we would be doing the uh, RBI guidelines or directions only on ARCs. So any questions that we can take up, Ankit?
So, of course, there's a Cersei related question. So, Cersei, I think I can explain to 𝐄𝐦𝐚𝐢𝐥 or on what I understand. I believe Cersei is a registry of mortgages that have been created by various banks, ARCs, financial institutions. And if the question is that, okay, if there is an entry which is already there in Cersei, and after that somebody has created another mortgage and they have again registered, or somebody has registered a property which is already appearing in Cersei as a mortgage, then of course that Cersei registration just helps the claimant, the banker for which where the mortgage was created, to exert its rights and say that this was public knowledge that this mortgage was in existence. And so ARC or banks or SARFAESI doesn't matter. The Cersei is merely a record of who holds the mortgage with respect to that asset. And of course, it is subject to the papers and the documents, which is the actual mortgage deed. The registry is only giving information to the public to caution the public on that. I believe we have a question from Mr. Ramesh Babu. We can ask him to speak. Maybe we can just take this one question because we're anyways running out of time.
Yes. Mr. Ramesh Babu can speak about his questions.
Hello.
Yes, please.
Hello, am I audible?
Yes, you are.
Yeah, regarding one small point, regarding the security receipts, every 6 months the security receipts are to be rated by credit agencies, credit rating agencies.
Yeah.
In case there is a fall in the rating, and to that extent, the provision is to be made either by the ARC or the bankers which are holding the security receipts. This small information just I want to add.
No, see, the security receipts are assets in the books of banks.
Yes,
And
sir.
the security receipts are not a kind of liabilities in the books of ARCs. So therefore, the provisions will have to be created in the books of banks. It will be created in the books of banks only.
Yeah.
Okay.
No, no. The security receipts are issued at the rate of 80 to 80%, 20% share receive.
Yes, yes, yes.
So 80% of the security receipts will be held by the banks.
Since it is
Hello?
an asset, it is an asset of the bank, it will be considered as an investment of the
Yeah,
bank,
instead of
and therefore the provisions will be created in the books of bank only.
yeah, banks as well as ARC also, because they
So
are
the
holding 20% of the
ARC will not
security
have
receipts.
any. So ARC will not create any provisions, because the ARC is issuing the security receipts, and when the ARC takes the assignment, and that also depends upon various kinds of assignments. If it is the assignment which is a 15%, 85%, or 50-50, so then the ARC, according to my understanding, will not create any provision, because see, for ARC, it is the liability only. For ARC, it is a liability. In case the ARC will bring security receipts in its books of account, then it is a liability. And as far as the liability is concerned, the provision can be created only on assets and not on the liabilities.
I think we're good. I think we are anyways running out of time, so we can close and then maybe resume this ARC topic next time.
Thank you very much. And this is nothing else other than our way of learning. So
And
we
please,
have,
please feel free to ask your questions offline. We'll be happy
yes,
to.
yes, yes. Thank you.
Thank you, everyone. Thank you so much.